Federal shutdowns aren't just political theater, they can freeze visa processing in their tracks. With LCAs on hold, what's left but H-1B? Well, today is what we're going to discuss real alternatives. So, friends out there, welcome to Immigration Talk Show. I'm Nipasa. I'm going to be your host for today's session. Stay with us, and we're going to have our guests join us. But throughout this whole session, I need you to keep this disclaimer in mind. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, once again, welcome, friends. And we are streaming live right now on YouTube, LinkedIn, and Facebook. Feel free to join us with your questions if you have any, especially with regard to today's topic. And the topic for today's discussion is government shutdown halts, LCAs. What are the alternatives to H-1B right now? And to help us discuss and get a few answers for the questions we have today, please help me welcome our guest, none other than Attorney Justin Rivera from Wasden Immigration Litigation. Hi, Justin. Welcome back to Immigration Talk Show.
Hey, thanks for having me.
Good to see you. And it's going to be interesting. I mean, with the government shutdown, I think we are all surprised and still waiting, as in what to do, all in a dilemma, in a limbo, most of our visas, and what should many of the immigrants do for their future. So, what do you have to say? What can we expect from today's discussion?
Just kind of going over what to do if you're in a situation where you're kind of screwed right now, where the labor condition application isn't processing or can't be filed, and you're coming up on the expiration of your I-94, so an extension or a change of status. It's actually pretty interesting. Yesterday, it looks like the USCIS has indicated that, and I'll use the language that they've stated because this just came out. They will exercise discretion to accept H-1B petitions that were not timely filed because of the government shutdown. So specifically, what they're saying is if the petitioner meets all other requirements and provides evidence demonstrating that the primary reason it did not timely file an H-1B petition with a request for an extension of stay or change of status was due to the government shutdown, USCIS will consider the shutdown an extraordinary circumstance beyond the petitioner's control as a favorable factor in determining whether to excuse the petitioner's failure to file an H-1B petition on time. So what does that mean? It means they're saying we will think about approving your case. If when you file, you can clearly establish that the only thing preventing you from filing was the government shutdown. It doesn't say that they will accept the case. It doesn't say that they will approve the case. It says that it will be considered as a factor. I think it's important to also distinguish, they only put two categories there: extensions and change of status. So amendments and transfers, you're just on hold, it looks like, which makes sense because a lot of the time that person's still going to have an I-94. So, I mean, it's a little bit of positive relief, but with anything with this administration, until I see them actually approving these cases, I will be weary of what they've said.
Yes, it's crazy, and we'll just have to wait and watch. And stay with us, friends. Comment wherever you're watching, and hello to Sid Mohan. Thank you for your questions and thank you for joining us. And we have Shamim also has joined us. So stay with us. We will take up your questions a little later in the show. And another best thing is that you can join us on call. In fact, Sid Mohan, I would request you to actually join on call because I see a lot of questions. We may not be able to take all of them, but join us on call. And the number is 436 425 436 6335. And when they ask for the access code, dial in 988 888. And don't forget to also subscribe to our channel. Our handle is at Immigration Talk Show. So, Justin, my first question to you for today's discussion is, because Reddit's on fire with this one. If the DOL's offline, does that basically mean the entire H-1B process is dead in the water until further notice? What happens to everyone stuck mid LCA right now?
So there's some debate in terms of thought on what to do. Some attorneys are saying if we have an in-process LCA, maybe we try filing with that, and then when we get the RFE, when the government reopens, we get the certified LCA and submit it to the RFE response that way. I don't know if that's going to work or not. I'm going to be completely honest. I'm not pushing anything to file right now. My understanding in looking at the regulations is that you need a certified LCA at the time of filing. If I want to use that as a weapon and I'm USCIS, what I say is when your case comes in and it's not supported by a certified LCA, I'm going to deny your case, and then I'm going to make the argument on top of that that we created a makeshift solution here in basically saying you can file late, and as long as you justify that it was because of the shutdown, we're going to accept your case. So yeah, I mean it's pretty much put a pause on the system that is creeping into a 1 month pause. And it's not great because not only is it a difficult situation for the employees, but the employers themselves are being put in a difficult circumstance because if they can't file someone's extension, are they putting them on unpaid leave? Is having them on unpaid leave an issue for them? Something I haven't seen happen yet, but I'm beginning to wonder about is if your case, let's say your change of status or extension, was in a circumstance where it was being filed and your LCA wasn't certified and it got hung up. Once you go over that threshold and your status expires, your I-94 expires, what's to stop you from getting an NTA? As the government have they put a kibosh on that? Have they said we're going to not issue NTAs right now for H-1Bs because we understand that people can't file? Or knowing this administration, are they more likely to issue NTAs with an understanding that there's a possibility that these people won't have approvals by the time they appear before the court? I don't know. It's unlikely to me that an NTA would result in something bad happening to these people because they have a very valid argument. The thing about the government shutdown is it's also impacting immigration courts. So unless you're detained, my understanding is your hearings are being moved if you're in any level of removal proceedings. So I couldn't really see that long-term happening, but it does create fear. And then there's also the underlying frustration of even if you're not someone who's in a circumstance where you're not going out of status anytime soon, if you got moved to a new project and your company can't file the amendment for you, you're just sitting around, or they're assigning you different duties. Are they letting you work remotely from the previous location? How does that even work? And then the people who, and I still continue to say this, are the most kind of screwed by this are your transfers, your people who may have given notice to the previous employer, not knowing the government was going to shut down, and then their LCA is stuck in limbo. What is that? What do we do for them? And so all of this is a difficult situation for people. And it's, in my opinion, it's made worse by the fact that I'm not pretending I'm dialed into into Washington, neither Hollywood nor Washington, but I'm not dialed into Washington. I have the same access to anybody else. I read, Washington Post, the Times, NPR, same stuff you all have access to. What I'm looking at tells me that we're not gonna, I can't see the shutdown ending anytime soon. There doesn't seem to be any actual negotiations that are taking place unless they're being taken place in secret and we don't know about them. But with politics, you usually have an inkling as to what's going on because all these people like to talk. And no one's talking about it getting closer. There seems to be the Democrats aren't saying they're willing to come to the table for a clean bill, and the Republicans don't seem like they're willing to meet either of the requests from the Democratic Party. So we're now kind of moving into a circumstance where neither party is willing to relent, and they're both going to begin highlighting the pain that's being suffered as a result. And my original prediction the last time I got on here and talked to you guys about the shutdown was that the shutdown would end before Thanksgiving, because my guess is that they don't want federal workers going unpaid into the holiday season. I still think that that's the case, but I am a little more worried than I was during our last call because there's just not been a lot of movement in terms of getting anything done. Everyone seems fairly entrenched and willing to let issues happen. I mean, they made carved out an exception for the military to continue getting paid. which was what I think each party was very willing to tout against the other as an issue. So once that becomes fixed, it becomes, okay, what about federal employees? What about this? What about that? I promise you guys, unfortunately, you're very low on the totem pole in terms of, oh, what about H-1B holders and their LCAs? It's just not, I don't think that it's a big deal for the government right now presently. So what we have to kind of hope is that the parties will meet relatively soon to come up with some sort of stopgap bill so that we can at least open back up this process and let people actually file LCAs.
Goodness me, I just hope that they have not accepted that the government will not be functioning for quite some time now. But what's happening is that just recently, I mean, the U.S. government just rolled out the $100,000 H-1B fee, and they still can't keep the LCA portal running during a shutdown. So doesn't make so much sense, right? What do you have to say about it?
So the clarification for the $100,000 fee was something that came out, I believe, yesterday. But it's pretty incredible. I mean, they basically put a pay.gov thing link that you go to pay $100,000 on top of all the fees that you paid to file an H-1B. Their guidance on who the fee applies to and does not apply to is still suspect to me. There's a way of reading that what they've put out, which claims that if you're in the United States filing a change of status to H-1B and you're here in the US, your company is subject to the fee. Now, this is confusing because it seems to run contrary to 212F, which is what the proclamation utilizes for its implementation, which is the idea that the administration can prevent entry of certain individuals in circumstances they deem fit. You're already here if you're filing a change of status. So I don't understand how that holds in court. We're going to have to see what that end result ends up being. I know for a fact the Chamber of Commerce has already sued on this fee. This guidance came out as a direct result of that because the policy was already so broad and impossible to interpret that they had to put something out. Now that we have this guidance, we now will play out before the courts whether or not the guidance as it exists is allowed to stand. My inclination presently is the same holding that I had when this all first came out, which is that I don't believe the government can enforce this policy for people inside the United States. I believe that the policy will be applicable to individuals outside the US who do not hold H-1B visas at the time the policy was implemented. That being said, the language is not that language currently on the government's website. So as they're saying it, it's everything that was filed, unless you're basically filing an extension or transfer an amendment. If you're filing a change of status, it would apply to you. That would basically mean that everyone in next year's lottery would be subject to the $100,000 fee. And I just don't see that happening. So I will say we still have to see what plays out in court. You got to understand, just because the government says something doesn't make it so. Our firm and other firms just made them back down off of the signature issue where they were trying to deny cases because they were submitted with electronic signatures. Now they're saying people are allowed to submit handwritten signatures rather than being able to deny the cases. So understand that their first draft is not necessarily what they're going to be able to enforce, but it is what it is for the moment.
True, that's true. And it keeps changing. So it's very important for all you folks out there to stay updated, look at the news, watch news, and don't forget to follow us. Our handle is at Immigration Talk Show. We bring you the latest information, the latest updates on immigration. So also, Justin, people are asking, is this even legal? Because employers are literally emailing workers saying, we can't file, the system's down. Can a shutdown really pause someone's entire career like that? Like how it's happening?
Yes, because the shutdown was never baked into the idea of the H-1B program. There was never supposed to be a non-functioning government because, like most things, the trains are supposed to run on time. And we have gotten into a circumstance, unfortunately, politically, where the government's going to be shutting down probably with a heightened level of regularity the duration is kind of going to depend, I think, on the administration in a position of authority, and who has votes in the Senate and the House. But it is. I mean, it's a legitimate issue. I mean, I saw a question someone had about what does this do for my strategy for a transfer or an extension. I'm advising my clients what we're doing at this time is basically prepping the case to file with everything but the LCA, getting everything together so that day one, when everything comes back online, we can file the LCAs for those cases and submit them within 7 days. Once, there's nothing stopping us getting our I-129 signed forms. There's nothing stopping us from putting together our support letter in our packet and just having the LCA prepared when we file. Any firm that is sitting there telling you we're not going to take cases because of the LCAs being on hold is just trying to get out of work. I understand that the LCA is necessary and it's the first step in a process, but there's a way to work around it to where you have everything in place that you file 7 days after the government gets put back in. Those are the cases that I think are going to have the highest probability of getting this discretion that USCIS is talking about. If you can show a pretty clear timeline that you submitted your cases 7 days after the government was reopened, because that was the timeline it took to get your certified LCA, or 3 days after if yours was pending already, and you filed right then, that's a good argument for discretion because it is the only thing that was keeping it shut down. The cases that the people who I see doing things that I don't agree with are the people who are basically saying, we're going to pump the brakes fully on cases and we're just not going to do anything. There are still other parts of a component of an H-1B filing outside of the labor condition application, and those components can be satisfied while you await the government reopening in order to fulfill the filing of the extension or the transfer.
Well, thank you so much, Justin, for taking that up. And I think we should definitely take a couple of questions from our audience out there watching us right now. So, Control, if you can display one by Sid Mohan. Or, yes, Robinson. Hi, Robinson. Thank you so much for joining us here on YouTube. Our handle is at Immigration TalkShow. Don't forget to subscribe. So he's asking, given the recurring nature of US government shutdowns, should Indian professionals and employers begin integrating alternative immigration strategies such as Canada's GTS or UAE's Golden Visa into their long-term workforce planning? What do you say, Justin?
Well, I would say I am a U.S. immigration attorney, so I can't advise about immigration matters for Canada or UAE. That being said, to the detriment of my profession, if you're making plans currently to immigrate places outside of the United States, I completely understand. I can't sit here and say with immigration being the tumultuous monster it is presently that I don't understand why people wouldn't still want to come to the United States. There are clearly issues with immigration, legal immigration, that are persistent enough that if you're thinking about permanent residency or a long-term strategy to reside somewhere, you might be thinking about somewhere other than the United States. Especially if you're a younger person, maybe you're somebody who just got your degree, just finished with school, and maybe you didn't get selected in the H-1B lottery. Yeah, I think it's worth exploring those options.
There you go, Robinson. Thank you, Justin, for taking that up. We have Shamim who's asking, sorry, Richard is asking, with the Department of Labor unable to process LCAs due to the shutdown, how should Indian professionals recalibrate their timelines and documentation strategy for H-1B transfers or extensions?
Yeah, I mean, exactly kind of how I answered it a couple
Yeah.
moments ago. Just you get everything put together so the LCA is the last piece of the puzzle. Everything else should be signed. Signed, sealed, and ready to go. And once you're able to get your LCA, get it, and have it signed, and you're done. You're good. We get the case filed. But there shouldn't be any circumstance where anybody is sitting there saying, let's just not do anything. Like, let's just hold until the government reopens. You can do that, but it's going to put you in a circumstance where you're bottlenecking your work. And, if you're a firm like me and I'm sitting here this week with 4 H-1Bs that I know I can't file LCAs for, but they're all H-1Bs that we've intaked, then I can take all the steps to get ready to file them absent the LCA. But it's not a kick your legs up and sit back on your desk thing. That's not the argument that should be posited here of, well, we can't touch this until then. There are steps that can be taken. They should be being taken. And then you resolve the issue, file, and ask for the government exception.
right? Use the time basically to prepare yourself for everything else. So thank you so much, Justin. Now let's take up Shamim's question. It's asking, I got rejected under 214B for my F1 visa with my F2. My sister, a US citizen, is my sponsor and petitioner. My parents are green card holders. Officer asked 4 questions, refused and refused. Please guide me.
Yeah, they think you're going to live in the United States. That's the problem. You have not gotten rid of the idea of immigrant intent. They're basically asserting that you have multiple family members that reside in the United States permanently, and they don't believe that you're coming into the U.S. to reside temporarily. It's a very difficult hurdle to overcome if you're a young person because most young people don't own property. So it's hard to establish that you have those ties to your home country, especially when your family or a great deal of your family is already living in the United States. So I'm not surprised at that decision at all. And I would say, absent of you being able to produce evidence contrary to it, such as proof of, residency, connection to additional family members or friends, you're going to be in a difficult spot. Because if I was a visa officer and I was looking at your case and I was aware that you had multiple family members permanently residing in the United States, it would lead me to believe that you might have an intent to permanently respond in the United States.
Justin, for taking that up. And I think this is an issue many folks are facing out there. So it's very important to show your connections to your home country and your need to return back there. So thank you so much, Justin, for taking that up. Let's take up one from Sid Mohan. I don't have an H-1B stamp yet. So will the 100K dollar fee apply when I go for stamping? Should one get the visa stamping before the 100K dollar payment collection begins?
Well, I mean, the 100K payment collection's already begun. So just yesterday, they dropped the link where you're able to pay the fee. Allegedly, if your case was approved before the implementation of the policy, you should be fine from the fee, regardless of whether or not the fee becomes applicable upon exiting the United States or not. So that being said, I don't think so. I don't think you're subject to the fee, but is the consulate going to understand that? Is CBP going to understand that when you're coming in? I don't know. I had a woman who told me, I think I've shared it on this before, but I had a woman tell me shortly after the proclamation was announced, when she was admitted to the United States, a CBP officer told her, hey, expect to pay that 100K fee for your extension. And she was like, I don't think that's right. That's not how the proclamation. And he goes, no, be prepared to pay it. So when that fee goes in with actual like implementation, I think it's going to be pardon my language, but I think it's going to be a shit show. I really think it is. I think you're going to have people who are not ready to understand who this applies to and doesn't apply to, having to ask for guidance. I have already heard from consular officials that the State Department right now is not really helping with issuing clear guidance on what it is they're supposed to be doing. Some of them still are trying to figure out what exactly they're supposed to be doing with social media post reviews for people on F1. And because they're literally like floundering and saying, I don't know what I'm supposed to do or not do. What's correct here? And the guidance is like, just figure it out. So yeah, I mean, look, I'm going to tell you this. Yeah, it shouldn't apply to you. I don't think it's going to apply to you if you're on an H-1B that was approved before it went into implementation. Until I get my first person who says otherwise, meaning they get stopped at the consulate or by CBP, I don't have a different take.
Thank you so much, Justin, for taking that up. I think it's important, all these views. So coming back to some of my questions, Justin, there's another post which is interesting, saying my LCA froze mid-approval and my OPT clock is still ticking. How do we even plan your life when the government can stop time, but you can't?
Yeah, I mean, it's a bad situation to be in because, like I was saying earlier, this when you're putting together the H-1B policy and how it operates, um, sorry. It's not supposed to happen this way, right? There's supposed to be a constant stream of running. The DOL shouldn't be shut down. They should be able to run LCAs. You know what's conversely kind of funny? I just thought about. So the DOL can't process LCAs right now, right? But I have a client that I'm working with that's under investigation by the DOL that got an email from the DOL on Monday asking for more information. So that DOL officer is working and maybe working with pay or without pay. I don't know, but he's doing his job because I guess he's essential. But an automated system can't run. Makes no sense. But all of that is, yeah, I agree with you. You guys are in a bad situation by no fault of your own. USCIS appears to have signaled that they're willing to be sympathetic to that when the government resumes operations. So there at least is some sort of exception carved out. But no, it's ridiculous. No government should ever be able to just shut down because it can't agree to how it's supposed to be funded. You know, it's asinine. It's insane. It's indicative of the absolute declining political abilities of our country. I don't know. I don't know how else to say it. Our democracy is just not doing awesome right now. And yeah, you guys are part of the people that are suffering as a result, which is unfortunate. I get it. It sucks. What I would maybe say is if your OPT clock is running and you're in a circumstance where you're not able to do it, maybe it's possible if you're running out of OPT days to roll that into a nunc-pro-tunc argument when the government reopens in the incident that you're going to file a change of status, and see if they're willing to give you a little bit of credence for that, like they've signaled they would do. But outside of that, your options are very limited. The thing that sucks the most about OPT unemployment, which I fundamentally don't understand, is that it accumulates while you are in or out of the United States. So if you're on an OPT with an OPT company and you get laid off, for example, and you leave the country, you still get dinged for unemployment days, which I think is so weird because in the H-1B program, if you're outside the U.S., those days do not count towards days on H-1B for a 6-year standpoint. So it's very interesting to me that the government looks one way at the H-1B visa and then another way at the F-1 in terms of OPT. But yeah, I'm sorry. I don't have anything positive to say to you. When the government reopens, file your case as fast as you can and hope that they give you an exemption.
Thank you so much, Justin, for taking that up. And it's crazy how I mean, all in a dilemma, I would say, all folks who are dealing with the visa, their statuses, what they are waiting for. But friends, thank you so much for your questions. Please don't forget to subscribe to our channel. Our handle is at Immigration Talk Show. Check us out on YouTube and also on LinkedIn, Facebook, X, and on Instagram as well. And Sid, Mohan, if you could actually join us on call, it would be great because it wouldn't be possible to take so many of your questions. We just have about 5 minutes. So I think I would take, a couple of questions from our Facebook audience as well. They are also waiting. So Control, if you can display at least one, please. Hi, folks. My I-140 EB to NIW was approved with a priority date of June 13th this year. I'm currently in the US on STEM OPT, which will expire in January 2027. Since I'm from Bangladesh and PD is July 15th, 2024, is it possible to complete or at least get the EAD or green card approved within this period? Thanks.
I don't know. I can't control how the visa bulletin is going to move. I would say to err on the side of caution and try and get yourself an H-1B visa in between now and the expiration of your STEM OPT, just so you have that safety backdrop in the event that it's not current in that timeline.
Thank you, Justin, for taking that up. And this next one, hi, I'm an F1 student, and this is my last semester here. And I'll be applying for OPT or STEM OPT at the end of my semester. I wanted to know, will the new rule of $100K fee will apply to me if I change my status from F1 to H-1B visa? I'm inside the US.
So my holding is that it shouldn't apply to people that are in the United States, but that is directly contradicted by what USCIS has put on their website. So my statement to you would be, I don't think it's going to apply to you, but I need to see what's going to happen with the lawsuit with the Chamber of Commerce before I know more.
Right, right. Thank you, Justin, for taking that up. Maybe another one, please. Hi all, I'm in India working with a well-known software company. I have H-1B visa stamped for my current company, but I never traveled to the USA. Can I switch my company now and get the travel opportunity from another company? Or I need to travel with my petitioner, which is the current company, to USA for the first time. What happens if I leave the current company and they revoke my visa?
So this is a very it's a very nuanced question, and there is a level of danger to it, to be blunt. If you get an H-1B visa stamp and never enter into the United States, is it possible to attempt entry with a different U.S. petitioner? Yes, it is possible, but it will be heavily scrutinized upon entry by Custom and Border Patrol. The reason why is they are looking for confirmation that you never had any intent to work with that employer. And what they will basically do is take you to secondary inspection and try to question you in regards to why did you get sponsored by this company? And then why didn't you enter the United States with this company? When did you decide to move to another employer? At the end of the day, what it all comes down to is what was your intent at the time you submitted your information for a visa application. If your intent was to work with the company, then there's no problem, particularly if you can document that. If there wasn't necessarily intent, for example, there was not an offer letter in place, there was no assurance of a project or anything like that, that is more problematic because when you enter with that new company, if you're not able to present that information, it's going to lead CBP to believe that your employment wasn't genuine initially. So, what is the safest route? The safest route is entering the United States with your current employer, coming in for 2 to 3 pay periods, and then seeking a transfer to another employer. That's the easiest way to get you through CBP. If that's not an option, then you can file a new H-1B consular processing for an individual that already has a visa, an H-1B visa, which should allow you to circumvent the 100K fee. But you are going to deal with issues upon entry to the United States with CBP. I have seen it happen multiple times, and I've seen it go both ways. I've seen the person be admitted to the United States. I've seen the person's visa be canceled and have them put an expedited removal where they're banned from reentry for 5 years.
Well, but thank you so much, Justin, for taking that up and opening our eyes, giving us your perspective and how to prepare ourselves. And it was very nice to have you answer so many of our questions very patiently. So before we go, if you could actually just tell us maybe, what are the alternatives to H-1B right now? Because the government shutdown actually halted the LCAs right now.
Yeah, I mean it's slim pickings to be honest. It's B2s, F1s in terms of NIVs for people on H's. You got your TNs if you're Canadian or Mexican, but that's a small part of the entire population of NIVs. But yeah, that's it. I mean, I think there's the O1 option, but if you're looking at an O1, you're going to need a couple months to prep that filing. I don't know if the government's even going to be shut down that long, but if you're somebody who thinks you could qualify for an O1 and you're maybe 2 months away from the expiration of your current I-94, probably be a good idea to start exploring that option just in case we're looking at a long-term shutdown. As I've told you guys, my kind of point of no return with this stuff is Thanksgiving. If we get to Thanksgiving and the government is still shut down, I would be shocked. But if it is, we need to be prepared for it to be shut down potentially until the end of the year or close to it. Because my understanding is some of those subsidies that the Democrats are fighting over expire in December. So if they get to that point, then they lose one of their bargaining tools, and I think that it might be bring them back to the table. But I don't know. It's not a great time for immigration as a result of all this. And bluntly, it's not a great time for the government. Period. I think that the fact that the government is unable to function in its present iteration is a testament to the lack of leadership that exists presently. So that being said, that's all I have to say about it without going full negative. It was a pleasure being here, and I look forward to being back. I hope next time I'm here, we are not talking about the government being shut down.
Same here, Justin. Thank you so much for being here. It was lovely having you. It's
You're very
just the
welcome.
time for a lot of maybes and what ifs, I guess, but I hope it'll get better.
Yeah. All
All
right.
right.
Talk to you soon. Bye.
Have a great day. Bye. Thank you, everyone, for joining us. Do not forget to check out Attorney Justin Rivera, and he's from Wasden Immigration Litigation. You can check them out on LinkedIn as well, and also visit the link which you can see on the screen. And that is Justin Rivera for you. I hope you had a great time with us and you got most of your answers. I'm sure we couldn't take each one of your questions, but as we discussed, I'm sure you got answers to your questions as well. So please do not forget to subscribe to our channel. Our handle is at Immigration Talk Show. You can check us out not just on YouTube, but also on LinkedIn, Facebook, X, on Instagram. Stay connected with us, because we come up with the latest updates with regard to US immigration, and you don't want to miss them at all. All right, thank you. And if you have any more questions or want to reach out to us directly, you can also WhatsApp me or email me. My email is nipa@staffingly.com. And you can WhatsApp or call me on my WhatsApp number. My number is 408-335-6444. For now, this is it, but stay tuned on Immigration Talk Show. There's a lot more great information for you. Bye for now.